The social media platforms came together under a group called Net Choice. And collectively, they sued Ken Paxton, the Attorney General of the state of Texas. And at issue is a Texas law recently passed that outlaws social media censorship, digital censorship in the state of Texas. Now, what I'd like to do is read from the sweeping ruling of the Fifth Circuit Court of Appeals, because it gets into the arguments at a level of detail that you rarely see in the media. Normally, you'll see things like, "Oh, Dinesh, these are private companies and they can do whatever they want." That is flat out nonsense on a whole bunch of counts. I mean, first of all, private companies cannot do whatever they want. Could social media platforms, for example, decide we're going to prevent blacks from using YouTube? No, they can't do that. That would violate all kinds of civil rights laws. And so the simple proclamation that these are private companies and they have a carte blanche to make their own rules and enforce them, we're beginning to see through careful reasoning why this is nonsense on stilts. This is nonsense on in a wide range of ways. Now, here's the court. The platforms offer a rather odd inversion of the First Amendment. This is in their own defense, the platforms. Here's the court. That amendment, the First Amendment, of course, protects every person's right to freedom of speech. But the platforms argue that buried somewhere in the person's enumerated right to free speech lies a corporation's unenumerated right to muzzle speech. I mean, what a brilliant and telling formulation. First of all, it picks up on something that the left has been telling us really now for years. Corporations are not people. And the court goes, yeah, that's actually right. Corporations are not people. And therefore, if you have individual rights in the Constitution, those rights don't automatically or to the same extent extend to corporations. It doesn't mean corporations have no rights, but it does mean that if an individual has a right to free speech and Congress can pass no law restricting freedom of speech, it doesn't follow that that applies to every corporation. So it doesn't automatically transfer from the individual to the corporation. And second of all, the court makes a very subtle point. It's one thing to say you have a right to free speech, which is a right to speak. What the platforms are saying is that they have a right not to speak because that right is not being affected. As the court goes into whether or not Twitter can speak. What we're talking about here is whether or not Twitter can muzzle other individuals from speaking. So in a kind of Orwellian inversion, these companies are using the First Amendment not to promote free speech, but to shut down free speech. And the court is very aware of this. It's probably an understatement to call it an irony. It's actually a flagrant violation of First Amendment principles. Let me continue. This is the court. The implications of the platform's argument are staggering. On the platform's view, email providers, mobile phone companies, and banks could cancel the accounts of anyone who sends an email, makes a phone call, or spends money in support of a disfavored political party, candidate, or business. What is worse, the platforms argue that a business can acquire a dominant market position by holding itself out as open to everyone, as Twitter did by championing itself as, quote, the free speech wing of the free speech party, and then having cemented itself as the monopolist of the modern public square. Twitter unapologetically argues it could turn around and ban any kind of speech it wants for no other reason than its employees want to pick on members of that community. Wow. This is fantastic stuff. The court is making two separate points, and I want to kind of go into them. The first one is this. Twitter claims to be sort of like a newspaper. Twitter claims to say, well, we are a newspaper. We can decide what content we want to feature on our platform. But the court says, no, you're not a newspaper because you don't exercise editorial judgment over everything that appears on Twitter or YouTube or Facebook/Meta. You don't operate like that. You're more like a platform. You're like a bank. You're like a ferry that is offering a platform for people to, let's say, cross the river. You're more like AT&T, a telephone provider offering, if you will, a forum for people to make calls and communicate with one another. And so do you have the right? Could AT&T decide, for example, listen, we don't like people, for example, who are libertarians. We're just going to interrupt their phone service, ban them. Even if they are following the rules, they pay their bill, they're not doing anything illegal. Nevertheless, we're AT&T. It's our platform. We're a private company. We should be able to do whatever we want. And the court goes, no, you don't have a right to do whatever you want. And so this notion that you have laissez-faire, carte blanche, is nonsensical. Now, the second point the court is making is that, wait a minute, you, Twitter, you, Facebook, you, YouTube, received federal subsidies and protections, including the Section 230 protection, by going to the government and proclaiming yourself to be a forum for the community, a way for people to communicate in an open and uninhibited manner, a kind of new public square. You said all this. You claimed that you were champions of open communication and free speech. And then the moment people signed on to your platform, because this is not just something you told the government, you also told the public that you were going to offer this. And the moment that you got a monopoly, you turn around and go, well, wait a minute, it's my platform, I own it. And so I get to kick anybody off I don't really want to have on the platform. And the court basically says you can't have it both ways.